The CCI in a recent order penalized certain public sector insurance companies for up to rupees 6.69 billion for bid rigging and for practices that caused an appreciable adverse effect in the market of health insurance. The facts of this case relate to a health insurance scheme promoted by the government of Kerala. Now, these PSICs or public sector insurance companies had bid for the right to provide insurance under this scheme along with other private players also. Now, an anonymous informant informed the CCI that bid rigging as well as certain unfair trade practices were taking place with respect to these health schemes. I'll discuss the facts of the case right now. The government of Kerala had invited certain tenders for the provision of health insurance under a scheme for underprivileged members of society. Now, certain public sector insurance companies as well as private insurers had submitted tenders for gaining the right to supply insurance under these schemes. Now, certain PSCs had also submitted tenders for the purpose of providing insurance under this scheme. Now, what I'd like to discuss next is the report of the Director General. Now, the Director General considered many evidences and looked into many orders and minutes of the meetings of these public sector insurance companies. Now, the DG came to the conclusion that the public sector insurance companies were engaging in bid rigging. Now, this was based on the fact that before the tenders were submitted, the PSICs would have a meeting wherein it was agreed that a certain company would emerge as the winner in the bidding process and that this company would share the business gained by subcontracting it out to the unsuccessful public sector insurance companies. Now, with respect to the conduct of the winning company during the period of the contract, it was noted that the contract was supposed to be for the years 2010 to 2013. But what was noted was that during the year 2010-2011 itself, within the first year, the company had chosen to exercise its exit option with respect to the contract. Now, what was noted by the DG was that for all the 3 years, the company that had won the right to supply insurance had strategically invoked its exit clause. Now, another fact that was noted by the DG was that in all these 3 years, the rates that were being quoted by these public sector insurance companies kept increasing steadily. Now, the Commission, on considering the DG's report and on consideration of certain objections that were raised by these PSICs, had framed two major issues. The first issue being whether these PSICs constituted a single economic entity. And the second issue was whether these PSICs had engaged in any activities which were in contravention of the Act. Now, with respect to the first issue, the Commission came to a very straightforward conclusion that these PSICs were not a single economic entity. The Commission noted that their shareholding was completely held by the Ministry of Finance. However, the Commission also saw that these PSICs engaged a high degree of independence, especially with respect to submission of tenders and decisions that were being taken. Therefore, there was actually no de facto control over these PSICs. Therefore, the Commission came to the conclusion that these PSICs were not a single economic entity. Now, with respect to our second issue, which is regarding the alleged contravention of the Competition Act. Now, the Commission noted, the Commission agreed with the DG's findings, especially with respect to the behavior of these PSICs. Now, one factor that was noted by the Commission was that in the year 2013-14, the party that had become eligible to supply insurance under the tender was a private company, and the rates quoted by this private company were much lower than the rates that were being quoted in the previous 3 years by these public sector insurance companies, and based on the consideration of all the evidences before it, the commission also came to a conclusion that these PSICs had engaged in bid rigging. Now, with respect to the penalty, we find something surprising in the jurisprudence with respect to competition law, looking at the way the commission has imposed its penalty. Now, the commission imposed a penalty of only 2% of the turnover of the PSICs. Now, if you put that in terms of figures, that's around rupees 6.69 billion. Now, when you're looking at such a big figure, one of the things that comes into mind is the solvency of these PSICs, public sector insurance companies, given the very important role that they play. Now, the commission also looked into such a factor and considered the solvency of these PSICs to be a mitigating factor. Therefore, the commission had reduced the penalty imposed based on this factor. Now, the commission also looked at another aspect with respect to imposition of penalty, which was the fact that these PSICs had colluded and had committed bid rigging with respect to a insurance scheme that was for the benefit of the underprivileged sections of society. And in light of this fact, the commission considered this to be an aggravating factor with respect to the imposition of penalty. Therefore, this seems to be a positive step by the commission with respect to penalties. And another takeaway from the judgment, from this order, is that even though an entity may be completely held by another entity, these entities need not constitute a single economic entity for the purposes of the Competition Act.